Welcome to Engaging Experts, the podcast that goes behind the scenes with influential attorneys. Our guests will describe their practice and expertise. Then we will go deep on various topics related to effectively using expert witnesses.
Hi, this is Russ Rosenzweig. I am the CEO and one of the co-founders of Roundtable Group, and also the host of this podcast series. And we have a great guest for you today. Brian Weinthal is a partner at the law firm of Burke Warren in Chicago. And he's also, in my opinion, one of the world's leading experts on using experts in the trial context. Brian is one of our beloved repeat customers at Roundtable Group for over a decade. Thank you.
Thank you for having me, Russ. I appreciate it. It's great to be here.
Well, I can't wait to dive in. And before we do, here's a brief sponsorship message.
This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Brian Weinthal, welcome again. So my plan for our podcast today is to introduce our listeners first to you and your practice, after which we'll dive into some of the nuances of how you use expert witnesses in your work as a litigator. Does that sound good?
Sounds like a plan, my friend.
So let's kind of start where I love to start, which is in college. And so you attended Johns Hopkins, which, not sure if you know this, Brian, but that university has a special place for us because Roundtable Group was actually founded in Baltimore.
Huh.
And one of my co-founders, Bob, was living in Baltimore. His wife, Sarah, was earning her PhD at Hopkins in public health. And one of our very first early visits to a university campus was at Johns Hopkins, where we were busy recruiting professors in the 90s to become expert witnesses. So how did you like Hopkins? And, did you know you'd go into law when you were there?
Well, that's it. First of all, that's a hysterical story, and I didn't know we were even further connected beyond my long-term use of you guys. But that's a great link, and shows you how 6 degrees of separation are a real thing. I loved Hopkins. I thought it was great. I have to tell you, Russ, that I always had a much stronger proficiency in English and the language arts. That might be based on the fact that I had a mother who was an English teacher for many years. She was the one the students hoped they didn't get because, of course, she would, senior year of high school, put an F on your paper if you used the wrong there, and there. But what I can tell you is at Hopkins, I definitely did not have the proficiency that many of my colleagues did in the math and sciences. Knew I was always stronger on the English and language arts side, and certainly always loved arguing in public presentation. So I think I had a very good idea while I was at Hopkins that I was going to pursue law school as a career afterwards. That had to do with 2 things. First was just my love of the language arts generally. But at the same time, it was going to be very difficult to turn a liberal arts degree into an appreciable and lucrative career with just simply a college degree. We were kind of getting to the point where college was no longer the first step into the workplace. It's now the advanced degree you need to go forward. So I realized that pretty quickly. Had a wonderful time at the school, got everything I could out of it, but I think I knew there was going to be further education in my future as I looked to what I was going to do next in the process.
Well, there's something else we have in common. My mom. Oh, can you hear me?
I can.
Oh, okay. My mom was an English as a second language teacher.
Too funny. You and I keep having these weird connections. That's great. Where did you remind me, Russ, where are you from and where did you teach?
New Jersey. This is all in Parsippany, New Jersey.
Of course. Well, I'm from Jersey. That's the other one that I knew we had in common.
Amazing.
Well, so that's too funny. That's great.
And here's something else we have in common. After Hopkins, you went to law school at Northwestern, which is my alma mater.
I did.
And so, wow, great minds.
Path. Yeah, great minds think alike. It's right.
But that's where we diverge, because after Northwestern Law, I believe you joined the Navy and the JAG Corps. So thank you for your service. That's a big deal. We are huge supporters of our veterans, and we donate a lot to veterans legal aid clinics. And I think our listeners would love to hear a bit about what it's like to be on the JAG Corps and what you did there.
Well, Russ, you're thanking me, but of course I see your online activity and a lot of your social media posts, and I know how supportive RTG has always been to our veterans. So I will thank you in return. Let me say that of the military, it was one of the most fun jobs I have ever or will ever have. Out of law school, I was doing things that many practicing lawyers, even today, don't get the opportunity to do. Cross-examining witnesses, planning for openings, actually conducting my own trials on day one. I'll never forget, I got out of the Navy's training program and got assigned an attempted murder case on my first day. I remember going to my office, reading the file, and then not knowing what to do after you read the file. What did you really even do next in a court case? And I'll never forget, they brought this 18-year-old that was accused of attempted murder to my office. And he looked at me and he said, "How long have you been doing this, Lieutenant?" So thinking on my feet quickly, I just looked at him with a very straight face and a nodding expression, said, "A while." Now, a while only meant 2 to 3 days earlier, but that said, it was still an incredible opportunity to get early experience in the courtroom day one. And I have to tell you, and I know we'll talk about this further on, later on in the interview, but even then, experts were a huge part of what I was doing. Even in the criminal space, experts had a role there and played a part. But that said, it was a blast of a job. I got the opportunity to do things I never would have had the chance to do had I started on the civilian side. That began with defending folks in criminal proceedings, young sailors and soldiers in criminal proceedings, and moved on from there to some more in-house counsel activities. But it ended, excitingly, as a prosecutor at Gitmo. I was actually a prosecutor for the detainees we have at Guantanamo Bay, the Al-Qaeda and Taliban members confined there, which was a mind-blowing experience.
Wow, you've been there?
Yeah, I've been there. I've seen a lot of the folks you probably heard of and interacted with them, and just a fantastic opportunity to do something that I think even nowadays people can't say. I mean, resume-wise, not that I'm touting resume, because that gets less and less important as you get older. Experience matters much more as you get older. But I can still say that I'm one of the few people that's actually had the opportunity to try an American war crime tribunal. So in terms of a job that gave me the opportunity to distinguish myself, nothing could have been better. I love the life. I love having that flat top haircut. Really, it was some of the best days of my life. Good time and a fun experience.
Brian, this is truly an amazing experience you had. I think we need to dwell just one more minute. I'm just so blown away. You were in a war crimes tribunal. Mm-hmm. Say a little more. Were you patriotically defending these people, or were you prosecuting? And what was that like? What was the emotion? Give us a sense.
It was an incredible time in American history. We're talking about the period roughly 5 to 6 years out from 9/11, and it was a fascinating time because in the country, if you were working for the government, your worth was being measured by your involvement with the intelligence community. How involved were you in Homeland Security? That's what essentially gave you your value or power in the American political government structure. For me, it was amazing to watch because I was part of a system that had been stood up specifically to try a very distinct group of people confined at Gitmo, and following a set of rules that, while I may or may not have agreed with them, I was not high enough up in the power structure to change those. Those were the rules given to us. So as a prosecutor, I had to make some very novel decisions, and that's what I was doing at the time. I was a prosecutor for the commissions. I had to make some very novel decisions. Chief among those was the discretion as to whether or not to use evidence obtained from what we were calling back then enhanced interrogation techniques.
Right.
That was an interesting ethical dilemma and an interesting look at American legal theory and an interesting on-the-ground decision-making process we had to use. I think a lot of people were very concerned with the idea of whether we could use this evidence or not, but it was rare that somebody would ask a prosecutor whether or not you should use evidence of that nature. Because for me, trying a case where I had a piece of evidence that might have been obtained through an enhanced interrogation technique may not fly too well in front of a group of average jurors who are hearing that evidence. What would they have said if that was used on them? A much different question than politicians were thinking of just simply, can we use it or not, and will it help us? Just because you can use a piece of evidence, as any expert will tell you, doesn't mean that it will necessarily be beneficial to you. But a cool opportunity to watch American history unfold. I think in many years, Gitmo will be much lamented in terms of a moment in history where we look at what the jurisprudence was and what we could have done. But it was a neat time to be a junior guy in that power scheme and see how things work there.
Well, what did you ultimately decide? Did you use the enhanced interrogation evidence? And, what were your thoughts on it then? And how do you feel about it now?
I feel then as I feel now, which is that evidence associated with information that may have been gleaned from enhanced interrogation tactics doesn't do much for you. If I was a juror, the way I approached it as a prosecutor was if I was a juror sitting in the chair, what would I want to hear? And if I heard evidence that had been obtained in that manner, it was not going to have true validity to me. It was too close to coercion, at least as far as I was concerned.
Right.
So as a prosecutor, I would typically make the election not to use that evidence. And I think it was the right call. Ultimately, we did a lot of good trying to focus on the true allegations we had against some folks. And I have to tell you, Russ, that as a defense or prosecution guy, when you're working in criminal law, I think it's important to always recognize that everything is gray. As a defense guy, every client you have has not been charged as part of a huge government conspiracy. Okay, there are, surprise, surprise, some guilty people out there. And as a defense person, you have to figure out the best way to defend those folks. As a prosecutor, not everybody truly is the axis of evil, and not everyone has truly engaged in the worst behavior you could ever imagine. I used to go up against the prosecutor for whom even the simplest crimes always got the maximum. Well, Your Honor, this sailor stole a CD from the Navy Exchange. He should get the maximum. Really? It's that kind of intensive crime that we should throw the kid in jail, for periods of time for boosting a CD. You got to look to the gray areas, and you got to play your case for as much as you can get, rather than always trying to shoot the moon on both sides of the house. That's what I took with me from criminal law.
Very well said, Brian. I think this is why we love so much working with lawyers like you. It's just the issues that you face are so intellectually interesting and philosophically profound. And by the way, I see a beautiful sword behind you. Does that have something to do with your Navy days?
It does. That was actually the sword that I would wear for formal occasions. There were very few of them. I have to tell you that sword wearing, other than weddings and a few other very top level occasions, you rarely put on a sword in the military, but that was actually my sword. So when I got out and went to private practice, I mounted it on the wall. I figured there's a great use for it because I don't get a lot of use for swords otherwise. So.
Well, you just went from cool to coolest.
Thanks, Russ. I appreciate it.
In my mind. And, we are a roundtable group, so some of us here
the coolest of the companies,
like swords and like the chivalric era. And wow, well, thanks for sharing that. Let's maybe transition a bit to your current work as a partner at Burke Warren in Chicago. And I'm really struck by the diversity of your practice. And many of our listeners are sort of fellow business owners and executives like me. And I was intrigued by some of the work you're doing in the context of defense of workplace grievances, allegations of discrimination, retaliation, hostile work environments. Would you like to share a bit about your work in that context?
Sure. Well, I think your listeners will be unfortunately let down in the sense that I'm way less cool nowadays than I was back in my military times. But ultimately, I have found a good niche in private practice with a great firm that I enjoy. I'm with Burke Warren. My primary bread and butter is litigation. My particular variety of litigation tends to be most focused on the workplace, helping companies deal with problematic employees, or hopefully helping companies deal with problems before they get to the point of explosion into litigation. That's really the most satisfying work I do, is to prevent the case from being brought in the first place.
Preventative maintenance.
Exactly right. A little ounce of prevention goes a long way in terms of preventing a claim from coming up on the back end. But ultimately, I help employers deal with workplace issues. Bottom line, that's what I do. That can take the form of what we think of as traditional claims, discrimination, retaliation, things like that. An employee doesn't get a promotion and argues that because of race, gender, or another protected category, that's why the promotion didn't happen. Alternatively, some employee in the workplace is being harassed by a manager or another employee, and the company receives a claim as a result. I essentially get involved and help the companies to get rid of or dismiss those claims in the most efficient, quick, and economical means that we can. Interestingly, my work has been changing both over the past year as the result of COVID, which we can get to, and also as the result of some decision-making by the Illinois Supreme Court, into two very different areas. The first is that I've been helping employers over the past, let's call it 10 months or so, deal with any issues relating to COVID. whether that be sick leave for employees who are eligible for it, paid sick leave under the FFCRA for COVID or becoming infected with COVID, or alternatively, issues relating to leave, disability discrimination, religious discrimination, as we now move into the era of vaccines and whether or not employers are going to mandate vaccines in the workplace. Fascinating issue, and I'm dying. I talk to as many clients as I can to figure out where they're going with this over the next few months, because once we have enough vaccine, businesses are going to have to decide whether they're going to put their foot down and require all employees to get it before everyone comes back. But the other big area that I've worked in thus far is what we call BIPA claims. BIPA is the Illinois Biometric Information Privacy Act. It's a very, very small, very unknown statute that says that if you capture any fingerprint, retinal, face recognition, or other biometric information from somebody, you have to have consent first. No one seems to know about the statute, and many, many Illinois businesses and businesses outside the state operating in Illinois are getting sued on it because they don't have the proper consents in place before they take that information. It's significant because Illinois is the only place in the country that has a private right of action. And to the extent businesses needed a reason to get concerned about it, Facebook just settled up to the tune of roughly $650 million for a BIPA class action asserted against it. So it's something to know about. If you have operations here, if you're in Illinois, if you're in any way taking biometric information in Illinois as an employer, you should absolutely look into the statute. Let me give you some free information about it, get familiar with it, and put the necessary consents in place so you're not the next victim of a class action lawsuit.
Yeah, Brian, I recently turned 50, and
you look great, Russ.
Thank you, brother. Thank you. Cheers. I was hoping for something like that.
Give me anything, right?
And sometimes, like when I read the news and hear stories like this, I just wonder if I'm kind of like in a different world between my mind and like what I read in the news. Like, back on the COVID topic, my octogenarian parents just got their vaccine. My parents-in-law just got their vaccine. Lucy, my wife, and I can't wait until they open it up to 50-somethings so we can get ours. And I just had this, notion in my mind, like, who wouldn't want a vaccine? This is like the miracle of the last 1,000 years that the vaccine became available so quickly. And, on the topic of biometrics, every day I start my Mac by putting my finger on it. And it just I thought it was a foregone conclusion that the way of the world is, biometrics in terms of security and entering into office buildings when we start going back in there again. And here I'm, hearing from you that, you could be subject to a lawsuit, a BIPA suit if that happens. So tell us maybe a little bit more detail on BIPA and, what companies need to know. And also, I'm very curious to hear your take on vaccines. Will companies mandate that?
So let's take both of those in segments here. So when it comes to BIPA, the requirements of BIPA are really deceptively simple. If you're going to scan someone's fingerprint or their retinal scan, or you're going to take a picture of their facial geometry, you need consent first. Now, how does this blow up into a lawsuit? What Illinois' BIPA says is that for every quote-unquote violation, you are subject to a statutory penalty of either $1,000 for a negligent violation or $5,000 for a reckless violation. Of course, because the statute was written many years ago, and because really the plaintiff's bar didn't key into it until some key decisions recently, there is no definition of violation. So let me explain to you how this works. Any plaintiff's attorney or member of the plaintiff's bar is going to argue that if their client came in the morning, scanned their fingerprint on a clock, left to go to lunch and scanned out, came back after lunch and scanned in, and then scanned out at the end of the day to leave, that those are 4 separate violations, entitling that person to $5,000 each for a total of $20,000 for one day for one employee. Multiply what that employee does over a 252-day work year by $20,000 a day. multiply that by the number of employees they have, which could be anywhere from 100 to thousands, and then multiply that by the number of years back that they can possibly go, since BIPA has no current statute of limitations indicated, for how long they want it. So to be clear, any BIPA action brought is immediately going to be in an unfair multiplier category of hundreds of millions of dollars in damages, when in reality, most plaintiffs probably have no actual damage of any kind to show for any scans that have been taken. Very few people have identity theft as a result of this because companies are really keeping this information safe. But that's how the plaintiff's bar is using it. You can get rid of those potential liabilities just by having the simple consents in place. But because most people don't know about it, once they get hit with the hundreds of millions of dollars suit, they're no worse for the wise. They don't know, they didn't know it was coming. And by that point, it's too late. You have a class action you have to try and get rid of. So that's the dynamics operating of BIPA at the moment. As I said, it's so ironic because simple consents put in place in about an hour or so of work by a law firm can really obviate or get rid of that potential liability.
Right.
That's why BIPA is so hot and it's such a hot topic right now.
Wow.
And the courts have shown extremely little inclination to allow defendants out of these suits. Very few ways to dismiss this once you get hit with them. Very, very hard to get rid of. On the vaccine side, it's an interesting question. Let me pivot now and talk about vaccines for just a moment here. At least thus far, Russ, my recommendation to clients has been, for the moment, while supply is low, strongly encourage, but don't require vaccination. So for the moment, tell your employees, we love it, we support it, it's a great thing, we strongly encourage you to go and get it, but don't mandate them to do so, at least until two things happen. First, we get enough supply of vaccine such that it's readily available to anyone who's able to go out and get it immediately. And secondarily, we see what happens first to the companies that are going to take the chance of mandating it. Let's see what their liability looks like before we go ahead and follow suit so that we're not at the tip of the spear. A lot of times I'll tell clients we want to be leading the charge. This is not a time I think when businesses want to lead the charge. So I think for the moment, based on supply and based on where the law is, I'd recommend that businesses strongly encourage, but not require employees to get vaccinated as a condition of coming back.
Very wise, Brian. Thanks for sharing that. If any of our listeners want to dive in a little more deeply with you on topics related to workplace grievances or BIPA or policy regarding recommendations for the vaccine, would it be okay for them to reach out to you?
Absolutely. I'm Brian with an I. The last name is Weinthal, Weinthal. I'm on Burke Warren's website, but I also have a very active LinkedIn presence as well, which is where I post most of my content that relates to this stuff and more. So please feel free to check it out. I'd love to speak to anybody that's got concerns in these areas because, boy, this is something where speaking to a lawyer early really can avoid problems like you wouldn't believe on the other end.
Well said. And I just made a note here on the topic of BIPA, sent an email to our in-house counsel to make sure we never implement biometrics in our company here. Risks are just too high.
That is a command level executive decision on your part, Russ, and I love it.
Now, I'm really struck by the diversity of your practice and all the work that you do at Burke Warren. And, I'm really moved that you have been one of our beloved, favorite, and best repeat clients when it comes to expert witness recommendations. So thank you for that. And,
absolutely.
You use experts a lot in the course of your practice. And, many of our listeners are your peers, litigators, who would love to hear your take on, beyond the expert witness recommendation side, which is where we focus our efforts. Once retained, what are some of your tactics and strategies and techniques for optimizing experts and using them well and managing them well, if you wouldn't mind to share?
Absolutely. Well, Russ, remind me, I want to come back to how I first got involved with RTG because that's important for your listeners to know. But let me say that when anybody in a case uses an expert, because experts are now pervasive, of course. There is almost no form or type of litigation I can think of where experts are really not the primary, if not sometimes the only witnesses that are really going to make the difference in terms of what happens in the case.
Well, that's the best news I've heard all year so far. Thank you for that.
Realistically, it's true on the business side, the commercial side. It's true on the employment side. Experts are pervasive. They're everywhere. So finding a great expert to go to bat for you in a case is going to be critical. As I said, I can't remember the last time I had a litigation that didn't involve an expert in one form, if not multiple forms. In terms of maximizing your use of an expert and in terms of getting the best out of your expert, what I find you need to do, it's critical to do, is make sure the expert knows their part in the story that you're telling. I think a lot of people retain experts and they say, Mr. Expert, here you go. Here's the documents I'd like you to review, and I'd like you to come up with an opinion on X. But I think you need to go beyond that when you work with an expert. I think rather than just siloing the expert or giving the expert the chance to look at a limited number of documents in your case, you actually have to tell your expert, what is the story that we're telling here? Well, the story, of course, is that X company looked into biometrics in these previous years. They found that biometrics was going to work well for them, and that ultimately, because of the research they did into that, they decided to make decision X, Y, or Z in the future. But what I really need you to do, Mr. Expert, here's where you come into this. As your part in this story, I need you to give me the feedback that a company that is a technology company or other company, whatever company X might have been, that the reason they would have needed to use biometrics in the early 2000s was this. Does that make sense, Mr. Expert? You need to give them their role in the story. They need to know, like anybody else, what part they're playing. And it's like when we talk about kids in a high school play. If the child doesn't really know where their character fits in, what they're doing, they're going to walk on stage, deliver their line in a vacuum, and it's over. If the expert knows what it is you're relying on them to do, they're part of this tale that you're telling to the jury, they're going to be far more effective in terms of communicating what it is that they're trying to get to the bottom of. And not only that, they're going to be more persuasive because they know what it is you're trying to do with what it is they're giving you. I find so many people work with experts and put them in this box where they only talk to them once a week on Tuesday and they only talk about the Smith report, which is what they gave them to look at. You can't silo them. You can't put them in a vacuum like that. The new federal rules obviously give more freedom for attorneys to speak and converse with experts. When I started doing this with you guys, it used to be that any document, any wisp of anything you had immediately had to be turned over to an expert and to the other side. Ultimately, it was discoverable. The federal rules have tightened since then. So there's a lot more freedom for attorneys to communicate with experts about theory and about what their actual views of the case are. If you're not maximizing your time with an expert to explain to them their role and what they're going to do, really, you're just letting the best opportunity to sell a persuasive part of your case go by. I see people spend tons of times with lay witnesses and just kind of go through this cursory analysis with the expert thinking, well, you're an expert, so you should be able to just deliver what it is you're going to deliver in a persuasive way. Can't work like that. You got to include them as if you're preparing a lay witness. Same kind of theory.
Well, this is such a nice insight and really kind of harkens back to the Hopkins story of studying English and I presume reading literature. And, what you're describing is a narrative. The whole dispute, strikes me, is a story, and an expert plays a key role in the story, and they need context. And to share that with them, like in this role as a storyteller, which, many great lawyers, if nothing else, are the best storytellers of our day. I just really love that. Can you, say a little more about that? That's quite brilliant.
Well, you hit the nail on the head, which is to say that all litigation, all trial work is telling a story. At the end of the day, you're going to have to stand before a group of 12 people that have absolutely no backing in this stuff and tell them a persuasive story. The biggest crime I think that lawyers commit in their practices is getting so involved in their cases that they can't explain it to somebody who has not been living and breathing it for the period of time they have. Let's be candid with the listeners. Litigation is a long, drawn-out process these days. Let's multiply that by at least double, at least here in the COVID era, because I have cases that are not getting a hearing for 8-9 months out from this point. But ultimately, remember that if you can't break down your story into something that literally a child could understand, you're going to go over the heads of people that don't have the backing in this stuff and that don't do it day to day. I'm not embarrassed to admit that I will oftentimes ask either my young cousins or their friends to hear me try a theory on them to explain it, because if I can communicate it in a way that makes sense to them, I know that I will have no problem communicating it to a group of adults that don't have the backing in law or don't have the backing in this theory. But boy, the number of openings I see where people launch right into, well, ladies and gentlemen, what you'll see in the Smith document is that the annualized rate for this, you've already lost them. You've already lost. Their eyes have already glazed over. You're talking about things. They have no clue what you're saying. You got to make it easy to understand. And you got to tell a story, not only that people understand, but that they care about it. Or if you're boring and they don't give a damn about what it is your client is aggrieved about, they're going to sit there. They're going to sleep. You're going to get the head, dipping back in the chair with the chin opening as you try to give a 2-hour examination of somebody. You need to make it interesting and easy to understand for anybody hearing it for the first time.
Yeah. Reminds me of, there's a small group of our clients that pride themselves on, when they do trial prep, they engage mock jurors who are all 7th graders.
Genius.
And there's just something to be said, the young adults, teens and adolescents, like, they get it. The emotion or lack thereof is what resonates with them. And just taking that simple storytelling narration idea and applying it into the expert context it's really quite great. Thanks for sharing.
Sure. No, of course. So I promised you I'd get back around to the beginning because I want to give your listeners some context in terms of working with RTG. So when I got out of the military, this was 2007, and I joined a private law firm for the first time. I saw, ironically, what I still see nowadays when it comes to people looking for resources in their cases. These strange, esoteric mailings that go out, talking about an area of expertise that I wouldn't have if you asked me when I was 87 years old. I don't think I would know a metallurgy expert in the Chicagoland area that can tell you the atomic weight of cobalt. But yet lawyers send these requests around their firms all day long. Can anybody recommend a good engineering firm that can do X, Y, and Z? The chances of any of these connecting with just simply asking anyone in your firm is close to zero, if not zero. So I was quickly a victim of this, or at least saw this back in the day in 2007 when I went private. And I said, there's got to be a better way than this. So I actually looked into, by doing some early networking at that point, various expert location services. I'm trying to remember if it was an email I got from RTG or if I actually met somebody. I think it was an email at some point that I got. And I said, okay, well, look, I don't know most of them from Adam. Let me try these guys. Met up with a name you'll know well, Mike Stern. I literally gave a call to the company. I spoke to a guy by the name of Mike Stern, who was one of the friendliest and most accommodating guys I think I've ever talked to. I forget what the expertise was, but it was something so bizarre that even nowadays I have a hard time remembering what it was. And within, I want to say it was an hour or two, Mike had for me at least 3 names of folks that worked in those industries that had incredible academic pedigrees, and that all 3 of which I was allowed to talk to and discuss with in advance of the case just to see who I connected with best. It blew me away because not only was it the easiest service you could ever possibly imagine, but ironically enough, I used whichever one of the experts it was I retained and did exceptionally well with that person in the first civil litigation with which I was involved at that point. So I was sold. I stuck with you guys not only while you were RTG, but for the period of time you went over to Thomson Reuters. Wow. Mike Stern was always my go-to. He's now retired. Wherever he is, I hope he's on a beach sipping a cocktail. He's now retired. And now it's exciting to be back with you guys, still even after the transition, because ironically enough, not even 2 days ago, I got a passed around message at my firm of somebody looking for an expert. I'm trying to remember what it was. Bridge construction weaknesses, something I never would have known, something I don't know anything about and will never, as long as I live, know anything about. So I immediately turned around and said, well, I know the guys to call. So it's incredible to still have this resource around. The messages still go around. I know that anybody in a law firm listening to this podcast is going to say the same thing, which is I get 4 messages a day from my partners asking for things that I don't have any clue about. Let me tell all those people listening, contact you guys, contact RTG, because it's easy, it's straightforward, and the experts I've gotten have just been fantastic. So I owe you a big thank you. This is coming after now 13 years of being stride step with you guys. So thank you for those. And boy, if there was any evidence for the persuasiveness that expert location works when you have a great service to do it for you, It really is you guys. So thank you for that, Russ. I appreciate it. I wanted to get that out there to you and your listeners because I appreciate it, and you have my sincere thanks.
Cheers, Brian. That's so gracious of you. I really appreciate it. We are humbly very proud of this small, tiny little role that we play in trying to make our judicial system, even better, because you're right, for 26 years now, God help me. I've been hearing our clients, litigators from all over the country, just talking about, we find our experts by asking around, who do we know? Who did we use last time? Maybe try to do a Google search. And it's just not that thorough. It's not that rigorous. For all these years, we've just been really trying to hone and refine and perfect that very process of making that a little easier for litigators.
It would probably be difficult for somebody not to find what they're looking for from you guys. And look, there's no parameter I've ever given you that you guys were not able to cover in terms of more greatly refining the type of expert I needed. If it was a person with this pedigree and this degree, could I also get testifying experience? Or could I also get report writing experience? Whatever it was. And you guys had access to it. Begrudgingly, much as it will pain me, Russ, I have to acknowledge Dan Rubin, who is now my current contact at RTG, who kind of replaced Mike Stern in the role he plays. And while it will pain me to do it, he is an incredible client contact. And I got to also make sure I acknowledge him, because not only does he get me exactly what we need, but he's a darn nice guy to deal with. And he and I are overdue in this pandemic for a drink out here in Chicago when he gets back out this direction.
Well, thanks for the shout out. Dan is great.
Bite my tongue and give that to him while we're on it.
Very gracious. We have 30 people here now, Brian.
Do you really?
Wow.
Most of my colleagues who work with lawyers like you are themselves lawyers. Or have multiple degrees next to their own names. So we're very proud of our people here. And I think to conclude, I'd love to hear just a little bit, if you're willing, about what you like to do, Brian, outside of work. What are your hobbies and interests?
Well, I'll tell you that I have an 11-year-old son who I absolutely adore. Connor is on the autism spectrum, so I spend a lot of time working with him and a lot of time helping him kind of appreciate and understand the world around us as best we can through the issues we work through. But that takes up a good amount of my time, and I love spending it with him every moment. And when I'm not spending time with Connor, I have to admit, and I don't think I've put this out there in any other context, but I am a closet nerd when it comes to tropical and marine fish keeping. So I absolutely love setting up aquariums, designing them, putting the right mixture of fish in there, taking care of them, maintaining all the chemistry of the water. It's an old habit that my dad and I got into years and years and years ago when I was a kid, and I've always enjoyed it. So I'll put that out there to the extent that that's a weird connection and hopefully resonates with somebody. But it's a blast and a good time when I'm not doing this law thing.
Well, thanks for sharing. Brian Weinthal, ladies and gentlemen, whenever you need help with any of your litigation matters and workplace grievances and BIPA and aquarium chemistry, Brian is here for you. Great to chat, Brian. Thanks again.
Thank you so much for having me, Rush. Appreciate it, and great talking to you.
Thanks for listening to Engaging Experts. Be sure to click subscribe so you don't miss our future episodes.